everyone, and welcome to Daily Newspaper Analysis, which is brought to you by LawSikho. So, today we will discuss only one article. This article is from the Indian Express, which is titled as Minding the Courtroom. So, this talks about the new, the suggestion that has been given by the Chief Justice of India regarding the National Judicial Infrastructure Corporation. So, what is it about, and how much is it feasible in the current time to have it, and what would it mean for the Indian judiciary in the coming times, will be discussed in this article. This newspaper analysis has been presented by me. My name is Sheva Khan. I am a BA LLB law graduate and I have completed my law degree from Uttaranchal University in the year 2019. I completed my graduation with a gold medal in my batch, and I have also been a national debater and a public speaker. Here at LawSikho, I'm working as an expert for current affairs, and I'm also working as the manager for current affairs vertical. Let's see what is the multiple choice question from our previous discussions. What is the present income ceiling for the economically weaker section category? Your options are 8 lakhs per annum, 7 lakhs, 6 lakhs, or 5 lakhs. If you know the answer, you can put it down in the comment section below. This is the descriptive question for the day. Discuss why there are concerns about National Judicial Infrastructure Corporation. With this, let's discuss the first and the only article for the day, which talks about minding the courtroom. So on 1st December, the Supreme Court gave wings to the CJI's vision of creating a National Judicial Infrastructure Corporation. Basically, we had discussed in our previous discussions as well that the NJIC, please do not be confused with the NJAC, which was the National Judicial Appointment Commission. That is altogether in totality, a very different thing that was regarding the appointment of the judges of the Supreme Court. But this is actually regarding the development and betterment of the infrastructure of the entire judicial system in the country. So this proposal was given by the Chief Justice of India, and please consider it was still only a proposal. But only recently, on 1st December, the Supreme Court gave wings to this vision of the Chief Justice of India. So a proposal on the same lines was sent by the bench to the Law Ministry to be considered and to be made concrete in the coming times. And the ministry has now been awarded 3 weeks within which it has to reply to the given proposal. Now let's see that why at all are we discussing this, and or why we actually are concerned with the topic of the National Judicial Infrastructure Corporation. Firstly, the NGIC aims to administer judicial infrastructure across the country. So we need to know that it will actually be aiming to administer the judicial infrastructure across the whole country, which means that it would include all the levels in the Indian judicial hierarchy, be it the Supreme Court, the High Courts, or even the district and the session courts. So some have raised concerns over the constitutional propriety, where Supreme Court slowly takes over the administration of district judiciary. Now, one thing that we talk about the Indian judiciary that is sine qua non for the proper functioning of the Indian judiciary is the independence of the Indian judiciary. So basically, now this independence that we are talking about is not just from the legislature and the executive and other departments of the government, but it also means independence from the hierarchical system as well. We, of course, know that the Indian judiciary has been placed in a hierarchical system, but still we need to make sure that all the courts, be it the Supreme Court, the High Courts, or even the district or the session courts, they need to be free and independent from the influence of the other. See, of course, a positive influence is something we all need because they are definitely a part of the same chain of line. But if at all we see that any higher authority has any kind of undue influence on the functioning of the lower authority or vice versa or any which way, so that definitely is detrimental to the health of the entire judicial system. So there has been an incremental shift of the administrative power in the hands of the Supreme Court. So when we talk about this, it is actually apprehended that the NJIC will shift or give a greater shift of the administrative power in the hands of the Supreme Court, and not just for the functioning of the Supreme Court limited, but also to the functioning of the district courts and high courts as well. So this says that this trend began with the All India Judges Association. So since the first judgment in 1991, there have been 3 incidents where the Supreme Court has been in a tussle with the state and the central government over the pay scale of the district judiciary. So basically, this comes out to be an administrative issue, but the Supreme Court was also into tussle, and maybe it didn't really have to. But here we saw what we are discussing about, not the separation of power, which is basically anti of the separation of power ideal, which is there under Article 50 of the Indian Constitution. Then we also have a case law here wherein in the case of Malik Mazhar Sultan versus UPSC, the Supreme Court was to decide the answer of a legal question which turned into a machinery through which the Supreme Court would overlook the recruitment of judges. And also, this was observed in the case of Imtiaz Ahmed versus State of UP, that what was basically a stay of the criminal proceedings turned into an assortment of judicial reform. So basically, we can see that a greater hand in the administrative power has been given to the Supreme Court, which definitely is not being liked by the other institutes, like we have, for example, the government. So the Supreme Court passed a new method of calculation for the vacancy of judges, which basically contradicted the Supreme Court proposed formula in 2002. And the same case has now brought the need of existence of the NJIC. Now, this also says that the court often appoints amici in these cases which fall short on the following grounds. Please consider that the amici is the plural of the word amicus, which basically is considered to be the friend of the court. So many a times in situation of whenever required, the court appoints an impartial person. Basically, he's an advocate. So generally, he's an advocate, a person who is like a guide to the court, who is like a friendly guide or a person who gives suggestions to the court. The plural of amicus is the amici. So the various in many times the court appoints the amici in these cases which fall short on the following grounds. Firstly, the amici have little experience of district courts as they are mostly senior Supreme Court lawyers. Also, they have very little time to dedicate to the policy research. And thirdly, they raise no questions on the lack of accountability mechanisms within the judiciary. So in this situation also it becomes a little troublesome many times, wherein a complete or wholesome picture is not portrayed. So the said procedure is undemocratic too due to lack of public participation, fragmented and also inconsistent system of working. So that was all for the day. We hope it was a good and easy session for you all to learn. If you liked it, please give it a thumbs up. And also, if you wish to download the PDF of today's slides, please be a participant on our Telegram channel. The link is there in the description box below, or you can simply scan the QR code that you can see on your screens right now. Also, please do not forget to follow us on our official Instagram channels for LawSikho Judiciary, CLAT Prep, UGC Net, Law Finance Exams, etc.